Hi everyone, welcome to today's webinar. We'll be getting going in a couple of minutes. We're just going to let as many of you as possible join us here in the Zoom room. Do say hello while you're waiting for us to start. Tell us your union, where you're from. We always like to hear that. Hi everyone, you're all very welcome today. We'll be getting going in about 30 seconds, maybe 60 seconds. We're just waiting for as many of you as possible to join us here. Great to see so many of you saying hello in the chat panel. Okay, afternoon everyone. I will start a bit of housekeeping on the webinar. So welcome, I'm Anna from the TUC. I'm joined by Phil Liptrot from Thompsons Solicitors. Thompsons are a great friend of the TUC. We've done lots of work with them together in the education sphere. We've done webinars, we've done live events. We work on them with training materials for you all. So we're really pleased to have Phil here today. We'll be getting to him in a minute. Lots of you are already saying hello, telling us where you're from in the chat panel. Please do that and use it to exchange tips, ideas, experiences there. We do have live captions on today's broadcast. There's a show captions button at the bottom of the video screen. Please select that to have the captions while you're watching. And we have saved some time for Q&A. We can put some of those questions to Phil towards the end. Once please post those in the Q&A panel. Sorry, I meant to say that. And we are, of course, recording today. If you miss anything or you've got to leave early, don't worry. We'll send you a link to the recording later today or early tomorrow, along with any resources that we've got on this subject. So, as I said, we're joined by Phil Liptrot from Thompsons. Now, Phil specialises in personal injury, accidents and injuries in the workplace. And today we're going to be talking about manual handling specifically. We're going to be talking about how these types of injuries can be prevented, how they're caused, and what the rep's role is in that, with both supporting members and holding the employer accountable when these occur. So Phil, over to you to take us through some of these key points.
Thank you very much, Anna. I'll just try and share my screen. Right, can everyone see that? You see that, Anna? Yeah, great. Right, thanks everyone. Thanks Anna and Yusuf again for inviting me. As Anna says, I'm head of personal injury at Thompsons Solicitors. I've been at Thompsons Solicitors almost 30 years now, frighteningly. And today I'm just going to spend maybe 30-40 minutes looking at manual handling and, as Anna says, how as health and safety reps you can help protect members and workers' health and safety. As I say, I'm more than happy to take questions at the end if you want to put anything in the chat, and Anna can pick those up. So there'll be plenty of time for that. So I'm going to look at the legal background, which effectively is the Manual Handling Operations Regulations 1992 and the associated guidelines, and really focus on what the employer's duties are. So in particular, Regulation 4. Spend a bit of time on this. And I appreciate that these regulations are, well, they're slightly, they were brought in just before I started at Thompsons, but and they've been around therefore for a long time. But I think it's really important and useful to refresh all our memories of the relevant sections as this is the cornerstone really of the employer's responsibilities and what you can do as health and safety reps and what you can rely on as health and safety reps when representing your members. And I think understanding and understanding and awareness of the regulations is key. We're going to look at some of the things to look out for in the workplace when it comes to manual handling, and finally consider how we can make a difference as a health and safety rep. And I'll be talking about that really as we go along, and how to support members to prevent injury. I will also very briefly look at how you can help if something does go wrong, and if a member is injured in terms of bringing a claim for compensation. So first, what are we talking about when it comes to causes and types of injury? Well, I've split it up, I suppose, into three categories. There's the one-off incident, so lifting a heavy box, and you feel your back go. That could be something to relating to working in a warehouse, for example. The cumulative heavier manual handling. So, for example, a porter in a hospital moving heavy cages 5 or 6 times a day over a long period of time, and suffering similar sorts of injuries. And thirdly, the repetitive strain type injuries, which include carpal tunnel syndrome, tennis or golfers elbow, and tenosynovitis. So these are caused by more frequent operations, similar to moving items, many items over a shorter period of time, but doing that every day as well. So perhaps lifting something on and off a conveyor belt for 5 or 6 hours a day. I think these are less common in terms of manual handling, due, for example, to automation, but we still see an awful lot of repetitive strain type injuries, so work-related upper limb disorders. So, for example, using a mouse, then that is a common cause, but isn't technically covered by the manual handling operations regulations, which I'll come on to. And why are we talking about manual handling operations and injuries caused by them? So how common are they? Well, you can see that 17% of all reported work-related injuries that are musculoskeletal disorders are musculoskeletal disorders, and you can see the types of the industries on the right of that slide where that happens. So the admin and support service activities are generally cause the repetitive strain type injuries, whereas the construction, transportation, storage, and other industries account for the first 2 categories that we've talked about. And you can see from the HSE data that there's 7.8 million working days lost, which is staggering, because that's per year in relation to these types of injuries. And I think it's always useful to have these statistics in your back pocket when discussing manual handling issues with employers, because these sorts of figures certainly focus employers' minds when we know that quite a lot of them put profit before people. But let's look at the regulations and what duties are imposed on employers. As I said, these are the regulations, 1992 regulations that are most helpful, and they have been updated over the years. I think the last update was in 2015, but it clearly states that this is what an employer must do when it comes to manual handling. And they must avoid manual handling operations. That's the starting point for any sort of discussions and negotiations and representations that you might make. You'll see that it is caveated as far as is reasonably practicable, which is a phrase that crops up on a number of occasions within these regulations and the guidance, and I'll come back to that later. Where it's not reasonably practicable, then they must assess the operations that are taking place, the manual handling operations that are taking place, i.e. the risk of injury. And they must take steps to reduce that risk of injury, again, to the lowest level reasonably practicable, and provide information to employees in respect of those operations. So the regulations are pretty clear on what an employer must do. And that is the starting point. There should be no manual handling operations. And I think that is the starting point for any sort of representations and negotiations as a health and safety rep. The second part of regulation 4 refers to the assessment that the employer must do if they can't reasonably practicably avoid the manual handling. And if there has been a change in the operations, let's say packaging has changed so that there are more items now in a particular box, and the box might have actually increased in size, again, to save money, then the employer can't rely on the previous assessment of that manual handling operation. And regulation 4.3 reaffirms this and also flags up other considerations, such as the physical suitability of an employee. It refers to clothing and footwear, which I'll come on to. It flags up that knowledge and training is an important factor, and also other risk assessments that have been done because of as part of the Management of Health and Safety at Work Regulations 1999. It also talks about if an employee is in a specific group that is especially at risk in relation to the manual handling operations, and refers to the health surveillance as well that may have gone on in that workplace. And again, we'll look at these in a bit more detail, because I think it's important to drill down a little bit so that we have that understanding and we're confident when we speak to employers about manual handling. But I just want to first spend a couple of minutes looking at some of the definitions, some of which are perhaps more obvious than others. So there's talk of injury in the regulations, and does that mean is it only a back injury? And clearly the answer to that question is no. It can be any part of the body. The main injuries that we see as personal injury lawyers are to the back, usually muscular or more painfully slipped discs. But we see a lot of shoulder injuries, rotator cuff tears, injury to elbows, particularly in that repetitive or cumulative category of manual handling, and neck injuries, particularly if we're lifting something over head height. Again, there's talk of moving a load, and the regulations and the guidance, helpfully describe this as a discrete movable object. So there are some distinctions which I'm not sure are particularly important when it comes to having these discussions with employers. But for example, if you were using a chainsaw to to cut some wood, then the use of that chainsaw in itself wouldn't necessarily be caught by the regulations. In many ways, it doesn't matter that much in my view, because there are other regulations that you can use, such as the provision and use of work equipment. And I don't think it's something that you need to concern yourself with too much, as I suspect most employers wouldn't be aware of that distinction anyway. And we talk about manual handling operations, but what are they? Some of them are fairly obvious. So, moving something by hand, but also any part of the body. So if you're carrying some scaffolding poles on your shoulder, for example, then that would be included. And moving covers a number of things. So transporting or supporting of a load. That includes lifting, putting down, pushing, pulling, carrying, or moving generally. So it really covers anything that includes moving anything in any sort of way will generally be covered. So there's a lot of things to look out for. It would exclude, for example, however, using a spanner to loosen a tight bolt, for example. So that wouldn't necessarily be a manual handling operation. And also to make it clear, really, what is meant by what sounds like a get out clause for the employer to some extent. So the reasonably practicable phrase is in the regulations, in all the guidance, forms part of the law relating to personal injury as well, and it's to balance that level of risk against measures needed to control that risk in terms of money, time, or trouble. So the employers can use that, but it's important to know that it's not just the risk of injury, but also the level of injury, and indeed thinking about the different scenarios where it may be relevant. So if a porter was pushing one trolley a week, 50 meters, then I think that an employer could probably justify saying that it's not reasonably practicable to pay £50,000 for a truck to do that job, for example. But by comparison, if that same task was being performed several times an hour over several hours a day over 5 days a week, then you can see that the risk of injury has significantly increased, and therefore the argument that something might not be reasonably practicable could be countered, I think. So in summary, then, the hierarchy of duties on an employer would be to effectively, as I say, remove all manual handling. So redesign that task, bring in automation or mechanize the process. And if that's not possible, if that's not reasonably practicable, then the employer needs to assess the risk relating to the manual handling operations that can't be avoided. And when they do assess that risk, what they've got to try and do is reduce that risk of injury to the lowest level possible. So again, it's that reasonably practicable point. So they give examples in the guidance of using a sack trolley or a hoist, for example, but also think about changing the task itself or the load. So again, if there are lots of items in a box, then reduce the size of that box, reduce the number of items in there. So again, that's something to think about as health and safety reps when looking at the manual handling operations that your members are carrying out. But again, just to dig a little bit deeper as to what this means. So can that work be done differently is the question, as we've talked about. So think about whether a different system could be used, a conveyor belt rather than lifting things between two surfaces. It's something just to always have in the forefront of your mind as to whether this manual handling operation is necessary. An example again would be, for example, if you're having to move patients, a porter in a hospital moving patients to get treatment, well, can that treatment be brought to the patient, for example? So it's trying to think sort of outside the box to some extent. And the regulation that we've looked at talks about a suitable and sufficient assessment of the risk. And the employer should consider all types of manual handling and also look at the other factors, which we'll have a little look at shortly when carrying out that assessment. So it's a pretty low bar when it comes to whether that assessment was suitable and sufficient to some extent. But we'll see shortly that it can't be a box ticking exercise, and we'll look at that in terms of what steps the employer must take to reduce the risk. Because what is an appropriate step? It's not a box ticking exercise, as I say. There has to be some thought behind it. The employer must also check that when they've put something in place to reduce that risk, when they've taken that step, that it has worked, and they must review that if it doesn't appear to have worked, if it doesn't appear to have made any difference. They have to reassess the steps that they've taken for them to be appropriate steps as defined by the regulations and the guidance associated with it. So look at the risk assessments for all manual handling operations that your members might be carrying out, and in particular, I think look at the older ones and see whether they need updating and whether they need reviewing and reassessing. So again, it's the employer just can't be doing this box ticking exercise when it comes to either assessing the risk, but more importantly, taking steps to reduce it. They've got to provide information, as I said, as part of the regulation. So what does that mean? Well, it means putting the weight where reasonably practicable on the item that someone might be lifting or moving, and also where items don't have a center of gravity that's central, then to give some indication as to where or which side that item is heaviest. A good example, I think, is in the airport and airport workers, baggage handlers, who have to lift suitcases, for example, and if a particular suitcase is over a certain weight, then there needs to be and should be a heavy label written on it, so that the employee and the worker is aware that this is heavier than perhaps heavier than normal, for perhaps, and that links into that training and knowledge that's been referred to. They have to take into account the physical suitability of their employees, And so size and strength, age, health are all referred to in the guidance. And these can all be factors. It's very difficult, however, I think, for an employer to consider the strength of someone. And I'm not sure how relevant that is in terms of the assessment that they need to make. Um, we looked at briefly, it mentions clothing and footwear. Well, what does that mean in practice? And is that something that you need to look out for as a health and safety rep? Well, the main clothing to take into account would be PPE. So if a worker is required to wear PPE, then and also carry out manual handling operations, then that needs to be taken into account. So if they're wearing gloves, for example, gauntlets, then does that interfere? Does that make it more difficult to carry out that operation? And the knowledge and training is something that also needs to be considered when they are assessing the risk and thinking about appropriate steps to reduce that risk. The employers, as we know, the employer is under a duty in relation to the Health and Safety at Work Act, but also the management regulations to provide appropriate training, appropriate instruction, because as the regulations and guidance point out, that the risk of injury increases without this training, without this knowledge. The regulations say that there should be consultation with employees regarding what training is needed, and by extension, the union reps, so the health and safety reps as well. And the employer must also consider who provides this training. So we see quite a few cases where, in particular, a younger worker or someone who's just started work in the employment has training by just watching how Dave does it because he's done it for 30 odd years, and then they might be required to sign a form which says that they have received this training in a particular manual handling activity. So again, it's something to watch out for when you are considering manual handling and what training has been provided. So just because, again, something's been ticked to say that someone has had the training, then do go behind that and see what the training was, who provided it, and whether that was appropriate, because it's certainly something that the employer must take into account. We've talked I talked a little bit about management of health and safety at work regulations, and again, there is a requirement under I think section 3 of that to carry out risk assessments, and those risk assessments need to be considered when the employer is looking at manual handling operations, as well as generally in terms of the workplace safety. And the management of health and safety at work regulations look specifically at young workers. We've mentioned this already, people new to the job. It specifically refers to pregnant women and also particular elements of workplace layout, which I'll come on to and mention shortly. So there's reference in Regulation 4 to specific groups of employees and whether they might be especially at risk in terms of manual handling. So it sets out these specific groups. So pregnant women, someone with a disability, someone who's had a previous manual handling injury or a history of back or knee problems is specified in the guidance. And I think that can just generally be considered to be any sort of previous injury or health issues. The capability of whether they can actually manually handle safely, and whether they are new to the job or inexperienced generally, but the opposite also applies if they are older workers. So again, I think the key, as most of you will do, but the key is to know your members and just be aware of some of the different groups that the regulations do flag up as being especially at risk when it comes to carrying out these manual handling operations. So I suppose what health surveillance we talked briefly about, sorry, and this is um, it's less important, I suppose, because there is no requirement under the regulation to carry this out. But if there has been health surveillance, then the employer must take that into account and consideration as well. So really, what to look out for as health and safety reps when it comes to manual handling? What are the red flags? So anything really where you're lifting something away from your body, from your trunk, or if you're twisting, bending, or in particular reaching upwards. So again, that awareness of what's going on in your workplace, then look out for these particular types of tasks. It doesn't necessarily, as it goes back to what I was saying about the particular type of injury. We had a case where there was no injury to the back, neck, shoulder. Someone was lifting or trying to reach for and lift off a tin of paint from a shelf above the head, and perhaps not surprisingly, the tin of paint dropped onto the person's head, and they suffered concussion, concussion syndrome, and but that was classed as a manual handling operation for obvious reasons. But again, it's a huge red flag when it comes to assessments and appropriate steps to reduce the risk if you are doing anything that requires someone to lift something either from above head height or to head height or above. Look at anything that might involve excessive movement, particularly if you're putting something or unpacking something and moving something from one place to the floor, and you're continuing to do that, because that clearly is a risk or an increased risk of developing any sort of musculoskeletal disorder, in particular, though, any sort of back problem, whether it's muscular or disc related. You could often see it unloading trucks onto pallets, for example, or indeed if you are carrying things or pushing or pulling things long distances. So if it's not just a few meters, but in fact it's 100 meters, either from one part of a warehouse, for example, to the other side. Order picking is a really good example of that, I think, where you should really be thinking about, well, firstly, can that be avoided? Obviously, but it needs to be assessed. Appropriate steps need to be taken to reduce that risk. And it's not just lifting, as I say, but it is pushing and pulling. And whilst an employer might, for example, have introduced a trolley to reduce, or a cage, for example, in a warehouse to reduce the risk of injury from a manual handling operation, that in itself potentially gives rise to a risk of injury. And so that needs to be assessed, and there have to be appropriate steps taken to reduce that risk in those circumstances. And again, think about workplaces where the rate of work is monitored, which I think is becoming more and more common these days, and goes back to to my comment about profit before people, and particularly with the introduction of AI when it comes to work monitoring, it's something that we need to be aware of, you need to be aware of as health and safety reps, as to whether that again gives rise to that risk and needs to be assessed. So those are the sort of tasks I think that can produce these red flags. And if we think about some of the actual things that people are moving, so are these things heavy? And a lot of this stands to reason. Are they bulky? Are they difficult to handle, difficult to grasp? I talked about that center of gravity point. Are they unstable? Are these containers that might contain liquid, for example? And so the contents will shift. So it's really important to think about that as well as the how they are moving these objects, but what the objects and what the loads are themselves. There's a case that we recently did where someone slipped a disc. It was a really nasty back injury, where what they were carrying wasn't particularly heavy because there were 4 people carrying it. It was part of an aeroplane, but made out of very sort of relatively light materials, and there were 4 people moving it. But because it was unstable, because it was flexible, then it was very difficult to handle. One person lost grip, and our client was injured as a result of that. So it's thinking about the loads themselves, but also where is this manual handling? Where are the manual handling operations taking place? So think about the workplace in itself. Think about the environment. And again, all these things are what the employer should be thinking about and considering. But it's useful, as I say, obviously for you to know this. So if someone's in an awkward position because of the layout when they're trying to lift something, and that's something that again needs to be considered. If the lighting isn't good enough and you're moving items in this unlit or not particularly well lit workplace, and you trip up, then again that is relevant to the manual handling operations that you're doing. Now, of course, there's some overlap with workplace regulations as well, but it's just something to think about. And again, think about the individuals. We've talked about this already, but the capability of the people who are carrying out the manual handling operations needs to be considered by the employers. So it's something for you to be aware of. You can see that the bottom arrow talks about special information or training for safe performance. And so an example of that might be if a worker is dyslexic, for example, and might need that training delivered in a different way, or if there are language barriers, for example. So again, it's just thinking about that. The employer has to be has to consider these points as well. I think it's useful just to remind people of the what's called the risk filters. And this is a diagram in the guidance that highlights that it isn't just the weight, as we've talked about, that the employer needs to take into account when assessing the risk, but where you're lifting something from and to when you are looking at that particular task. And you can see the pretty significant differences between lifting something at waist height close to your body and putting it down at waist height close to your body. So for the for women, then 16 kilograms would be a weight that wouldn't necessarily require a risk assessment as such, or appropriate steps to reduce that risk. Whereas if you were moving something from waist height to above shoulder height, and in particular if you were reaching out when placing that, for example, the paint pot that I talked about, then you can see that the weight there in terms of risk is much less, only 3 kilograms. And so what other tools have you got as health and safety reps? And it probably comes as no surprise to refer to the Brown book um, as really the health and safety reps Bible, and that that should be the first port of call really, because this the 1977 regulations gives, along with the Health and Safety at Work Act, gives you the right, or the union a right to appoint, or workers a right to appoint health and safety representatives for you to investigate and inspect the workplace and make those representations that we've talked about, and obtain the relevant information from the employer, and also to form safety committees. I think there could probably be a training session in itself in relation to the Brown book, but again, that is the health and safety reps Bible, and I know that there's been a recent republication, which I think Anna will speak about.
Shall I say it
Um,
now?
you can do, Anna,
Yeah, just to
yes.
give you a, let me see if I can show you this, turn my, not sure if I can turn the blur off. Okay, hope you can see that. This is a reprint of the Safety Regulations and Safety Committees, the Brown Book. We did it earlier this year. It's available here, as you can see. It looks lovely. We've just posted the link where you can order them from in the chat. As Phil says, it is a safety reps manual, really, for everything. Gives them all the regulations and all the guidance they need to carry out their role in the workplace. So do order them. There's a discount if you order in bulk. If you perhaps want to, if you're a branch secretary or something, you might want to give them out to all your reps. You can order them in bulk. While I'm here, I'm gonna just mention as well that next week is Union Reps Connect. It is the biggest gathering of reps from multi-unions that the TUC holds in the year. It's in Birmingham. Phil's coming to do a workshop. I'll be there. You'll be able to get your hands on some of these as well. If you've not registered, please do so. It'll be great to meet many of you there. I'll hand back to you, Phil, just to finish this off before I put some questions to you.
Great, thanks, Anna. So I just really want to touch, as I said at the beginning, on what happens if something goes wrong and someone is injured, and again, where you as health and safety reps can help. The session last year that I did looked at this in some detail, but I think it's useful to remind people that, perhaps not surprisingly, what is really important when it comes to winning a personal injury case is having the evidence to support the allegations of negligence that we make against the employer, and the injured person themselves is the most important person to give evidence, provide evidence. Witnesses, work colleagues are probably second in that respect, but your knowledge of the workplace, even if you don't have any knowledge of the accident itself, is usually vital certainly in making a difference between winning and losing a case, where it might be finely balanced in terms of negligence and indeed evidence. And the sorts of things that we need in terms of documents, for example, or indeed witness evidence, is whether there's been any previous accidents, whether there've been any near misses, complaints, or requests for changes. And again, you can see how this is relevant to the types of tasks that we've talked about, and the manual handling operations that we've talked about today. Whether there have been any risk assessments, when were those risk assessments done? And we ask for this information from the employer, but it can take some time to get this, or they can just ignore us, requiring us to make a pre-action discovery application, which again takes time because of the delays in the county court system. So any of this information, or all of this information, should hopefully be available to you. We talked about the the knowledge and training with specific reference to the regulations, and whether there's been any changes to the system of work. So if something has happened and you're aware of any of this information or evidence, then we want to hear from you, because, as I say, there's numerous cases where that's made a huge difference as to whether a member gets compensation or not. Just a reminder, because I think it's always useful, that when we're talking about accident cases, then there's 3 years to issue court proceedings. If it's a disease case, so again, it might be a repetitive strain type injury, where it's not just one specific incident. When we're talking about manual handling, then it's 3 years from the date the person realised or should have realised that this condition was work related. So normally that would, if, for example, they've been to the GP and there's a reference to work and the GP makes a record of repetitive work, and gives a diagnosis that is consistent with that, then that probably would be the date of knowledge. Just a reminder, general time limits if someone's assaulted at work, if indeed that person or a person is a minor, so under 18, there is some discretion from the courts if court proceedings are issued outside the 3-year time limit, but that really can't be relied upon. So if you are aware of someone having been injured at work or indeed outside of work, then do make sure that you advise them to contact their union, so that they can start the ball rolling. Because going back to the previous slide, which talks about evidence being really important, then the sooner we are able to talk to witnesses, to request documents, to look at documents, then again, the better for the member. And as I say, we talked about this last time, the good news is that if someone is a union member, then they will get 100% of the compensation, compared to high street firms of solicitors who'll take potentially 25% of somebody's compensation. So that's it from me. I'm more than happy to take some questions from Anna, from anyone else through Anna. There's some resources on our website, and if you've got my email address there as well, if you wanted to email me about something specific, then, or indeed if someone that you're aware of has had an accident or suffered has got a condition at work, then feel free to let me know. So I'll hand over to you now, Anna. Shall I stop sharing?
Yeah, that would be great. Thanks, Phil. And thank you so much for covering so much of the law, how it applies. And I think crucially, how reps can use that to take a preventative approach. If I was to pick out the one bit of it that I think reps should take away, it's like, know your members, know what their situation is, perhaps, a previous injury they might have, or health, or while that might be information that's confidential, it might be something that you can will help you apply the right technique into reducing the potential for an injury in the first place. I think, of course, as well, the inspection of the workplace is very important in getting that information. And of course, the brown book, I'll hold it up again because I've got a bit more screen space, is where you get the right as a safety rep to carry out those inspections. Okay, I've got a question for you, Phil, that hasn't come up via the audience, but when it comes to health and safety, we often hear talk of the Employment Rights Act, Section 44. Does that apply here? What can you tell us about that?
It can do, and it comes up quite a lot, because a lot of people are aware of this. So what this says in brief is that if someone is in imminent danger in terms of their safety, then they can leave the workplace in effect. And whilst that is correct, and the Employment Rights Act does give that right to an individual, as union reps in particular, we need to be careful about that, because say this is an individual person's right, and if a union rep was found to have encouraged people to leave the workplace, then there's all sorts of issues when it comes to sort of industrial action law. And it's quite a high bar. The cases that have dealt with this as to what imminent danger is. So a lot of people looked at this during COVID and whether that might actually apply. And it was our view was that it would be very difficult to say this was imminent danger. So you're thinking about a gas leak, something like that. There might be a risk of explosion. Then certainly in those circumstances, perhaps not surprisingly, it would be fine to leave those premises. But in terms of, in particular, the manual handling operations that we're talking about, very few of those that we've thought about today would apply to that. So it is something that many people, many union reps are aware of, this being a right, but it's something that needs to be treated with extreme caution when if you think that this might apply to your particular workplace. So the advice would be to speak to your regional officer in the first instance.
Yeah, thanks, Phil. That's really helpful. We've had a few questions about training that the employer should give. So I'm going to kind of group those together. What level of training would be best practice for someone who is moving things around or handling things? And if an employer refused to give training in these circumstances, would that be unlawful?
Yeah, I mean, the level of training, I suppose it would depend on what, again, it depends on what the task is. So if it was a straightforward, by way of example, lifting a box from the floor to the table, then, if that person, lots of employers, particularly now, use online training, and that might have demonstrations, videos, diagrams of how you can lift these objects safely. Then I think that would probably be sufficient. I would have thought. I think an employer would probably be able to say that they'd taken, they'd assessed the risk, and they'd taken appropriate step. I think if that task is more complicated, or indeed if the consequences of an injury were severe, then I think then they might have to do more detailed training. I can't off the top of my head think of what that might be, but again, I think you need to look at the type of task, and I think comparing it, I suppose, to an employer that says, well, the supervisor said you need to bend your knees, that's probably not enough. But as I say, showing someone a video for 15 minutes on that simplest of tasks, perhaps, then that probably would be sufficient. In terms of employers who don't provide training, I mean, there isn't really a legal redress in respect of that. Unfortunately, you would need to, and again, it comes back to what we always say as lawyers, is that an industrial solution is often the best solution. So your power as a health and safety rep to make those representations, to highlight to the employers what they need to do, and again, report. If you're concerned about that, report them to the HSE. Now whether that makes a blind bit of difference or not is another question, because of the resource issues that the HSE might have. But again, certainly flagging these issues up with the region in your union, then that would be the first thing to do. And again, highlighting those issues, putting something in writing, then that at least, if nothing else, provides that evidence that this has been raised and this is a foreseeable risk of injury that could have been avoided if something does happen. But again, it goes back to that industrial solution. If you are a health and safety rep in a dangerous workplace, then you need to raise that with the union regionally, and potentially that may result in some sort of industrial action if nothing happens. But so that there is quite a lot of, whilst there's no sort of specific legal redress, and there's a lot of power in the union, as Billy Bragg might say.
Absolutely. And I think, as we say, for all workplace situations, if you have a workplace issue, see if it affects more than one person, more than one member. If it becomes a collective issue, that will then give you a case and evidence to go to your employer with, whether or not, as Phil says, there is a legal redress. You've got that group grievance, I guess, with the situation in the workplace. Okay, I wanted to ask you if there's any weight restrictions at all under the law. Our viewer asks specifically in the case of home carers, but I'll broaden it out and say, is there anywhere where it talks about an actual number as a weight restriction?
I mean, there isn't really. I mean, I say that the first point, the starting point is you shouldn't be manually handling, and I think that is the starting point for all manual handling operations. And in terms of the guide, I mean, the guidance is really good. I mean, I talked about the Brown Book, but the guidance to manual handling operations regulations is a really good resource and goes into a lot of detail about different types of manual handling operations. And again, in terms of home carers, then it's been, well, when I first started, there shouldn't be any patient lifting going on. There was I think the drag lift and was it the Australian lift or whatever I think it was called, that then they were supposedly outlawed 30 years ago, and there must be hoists available. That there are different types of moving equipment that's available. So really, particularly in that home carer situation, there shouldn't really be many situations where the anybody should have to manually handle a patient. And if that is the case, then there has to be a proper assessment of that task, and appropriate steps need to be taken to reduce that risk. But no, an employer isn't going to be able to say, oh well, this patient was only 12 stone, so that was fine. But this one is 18 stone, so that's too heavy. So no, that certainly shouldn't be the case.
Thank you. You mentioned, when you were talking about risk assessments, that sometimes an employer might do a, in quotes, box ticking exercise with the risk assessment. Could you give us a couple of examples of what it might be if they're just ticking a box? What are they ticking, basically, so that they can say they've done it without it being thorough?
That's a good question. So I'm trying to think of it. So again, I suppose an example might be looking at the maybe the patient handling side of things. If they've not really addressed their mind to the capabilities, for example, of that particular patient, their needs, if they've not thought about the capabilities or individual capabilities of the employee, for example, then I think if all they're saying is, I have assessed the risk and there isn't one, and there's nothing else on that sheet of paper, if you like, then I think that they would be in difficulty. I think if as a risk assessment, and I suppose it still might be a group of boxes that they tick, but if there is a breakdown of what they have considered, and they can show that they've considered everything in terms of, say, the capabilities, the individual well, everything that we've been through really in terms of the factors that they need to consider, then I think they would have difficulties in saying that this was a suitable and sufficient assessment, or more to the point, I suppose, that there were appropriate steps taken. So I think it is really the level of detail, and it does go back to the task in hand. So again, if it was moving something that was 5 kilograms, and they say there is no risk of injury here, then I think that is very different to that patient handling scenario, for example, where there's the medical needs of the patient, the environment. So I think really it does go back to the task in hand, as to whether as to the level of detail that's needed when assessing that risk. I think training is a very good example of box ticking, I think, but I suppose it's difficult to give a specific example. But I think look at the task that they're doing and how complicated that might be, or how many different factors there might be in relation to that task is probably a good way of thinking about it.
Thanks, Phil. I think maybe that would be good to leave it there on a difficult question, as we've also been going for an hour. So thank you so much for today. Don't know whether you've had a chance to see in the chat how many people have said it was really helpful. It was, they've learned a lot by listening to you during this session. So thank you for
Oh,
that.
good, thank you.
Don't forget, everyone in the audience, you can come and meet Phil next Wednesday in Birmingham. You can come and meet me at Union Reps Connect. I hope to see many of you there. Tune in again soon for another webinar, and have a good rest of the week. Bye bye for now.
Thanks, everyone.